All right. Well, hello again, once again. My name is Lior Samfiru, and I am excited to be here as always. Thank you very much for joining me on this new live session that we have on Facebook, on YouTube, talking about employment law, talking about workplace rights. So again, for those joining us for the first time, welcome. My name is Lior Samfiru. They call me the employment lawyer. And they call me that because, well, that's what I do. I handle workplace issues, I resolve workplace issues, I advise employees and employers about anything to do with your job, with your compensation, with anything that you need to know if you've worked, if you are working, or if you're having any kind of workplace problem. So you may be asking, what do we do on this session? Why are we here? Well, I'm here for one purpose, and that is to answer your questions. I am live, I'm here. And I've done this so that I can answer your questions and hopefully help you solve whatever problems you're dealing with. So take advantage of the fact that I'm here, that I've set aside this time for this purpose, and ask your question. I don't care what you're facing. There are solutions. There are answers. There are things that you can do. There may be things that just happened. Maybe there's things that you've always wondered. No need to wonder anymore. Ask your question. A lot of people may have lost their job recently. COVID-19 has impacted us all. If you lost your job and you want to know what you're owed, or can you even lose your job, now is the time to ask. If you are in a temporary layoff and you want to know when that darn thing is going to end and when you can get back to work, ask. I will tell you. If you've been mistreated by your boss, if you have been suspended or put on a performance improvement plan and you want to know what to do about it, how to respond, how to deal with it, there are so many questions, endless questions really, and now is the time to ask them. I will answer, I will give you what you need to know. Now, before we get started, let me give you some other contact information. And I do this because you may have questions that you don't want to ask right now on Facebook or YouTube. You may have questions that you want to discuss with me privately. So not a problem. You can contact me by phone, by email. Let me give you that information. All you need to do is you go to employmentlawyer.ca. Again, it's employmentlawyer.ca, and you'll see all the contact information there. You can send me an email, you can give me a call, you can send me a fax, you can send me a pigeon. Whatever you want, you can do, so you can reach out and we can have that private chat about your workplace rights, and hopefully I can give you some guidance. But that's for after. Right now, hey, I'm live, you're live, I can see all the people watching, so please, please ask your question. Don't be bashful. Don't hesitate. I have plenty of stuff to talk about anyway today, but it's more interesting for you and for me if you ask questions. So don't hesitate and we will get that answered. I'm going to start with the first question, but in the meantime, don't wait, guys. Ask, ask, ask. From Denise, I've been working in the office for the last year, except for 2 weeks last year. My employer recently requested all staff to work from home, as he is bringing his children into the office to be homeschooled. I have coworkers who live in the country and have unreliable internet and can't work from home. What are your rights regarding a boss bringing their primary 8 children to the office at this time? So that would not actually be appropriate for your boss to do. But if your boss can do this safely, then that would be okay. Certainly not to expose others or expose the children. But the bigger problem here is your boss can't just tell you you have to work from home, okay? Even during COVID-19, if the workplace can otherwise be kept safe, if there's no government requirement saying that you have to have people working from home, you actually can't be made to work from home, again, as long as the employer is otherwise allowed to operate. Now, the real problem here is this. Do you want to get into a big fight with your employer over this, or do you want to humor your employer for the next little while the children are there? If you want to treat this as a constructive dismissal, you can. I don't know if that's a good idea right now. It's a very unique time. Can your employer make you work from home? Not unless, of course, the workplace is unsafe or they're required by government not to have people in the office, okay? So hopefully that gives you some guidance. I would probably let this one go just because it's very, very unique situation that we're dealing with right now, COVID-19. Thank you for that question, Denise. You do the same thing as Denise did. Ask away, ask questions that you have always wondered. And in between your questions, well, before I even do that, another question just came in. I'll answer that right now. See how easy it is, from Yolanta. and if I mispronounce the name, I apologize. Is the employer required to tell all employees if there was a COVID case in the workplace? Certainly any employee that may be impacted by this, that may have come into contact or may have been exposed, or any employees that would be put at risk, the employer has to tell them. If it's an employee that's working from home, for example, that employee doesn't have to be told that there was a COVID case in the workplace. It's a good practice for the employer to say that to all employees, but the obligation is to tell employees who may be impacted, who may have been in the workplace at the same time, who may have been exposed or may have been in contact with the person who had COVID-19. Those employees must be told, because we have to start tracing. These employees may have to isolate. They may have to do contact tracing. So yes, but if there's no chance of any exposure, if the employee at question was away or off, then at that point, no, the employer won't have to say anything to those employees only. So Yolanta, if you have a question specifically about your situation and what happened, ask now a follow-up question. I'll be happy to answer it. See how it is, how easy it is. Yolanta asked a question, I answered it, and now she has that information and she knows what she needs to know. So, okay, so from Northern Mustangs. So by the way, I do accept Mustangs as payment. Typically, how fast is a settlement for constructive dismissal made? So obviously, every case is different, and here's what I mean by that. You know, in a way, you're kind of asking, how long does recovery from surgery take? Well, it depends on the surgery, right? Is it a surgery for an ingrown toenail, or is it a surgery for heart transplant, right? So every surgery is different. Every constructive dismissal case is different. On average, it takes 2 to 3 months to resolve a constructive dismissal case, okay? Now, some cases could be much faster, some cases could be longer. But, you know, 2 to 3 months is what I would put in as an average for a constructive dismissal case. But again, every case is different, just like any medical procedure is different. So we have to compare apples to apples, all right? But thank you for that question. Glad that you've asked it. I'm gonna just I'm gonna give a word here to my colleague Dan, who is watching this today. By the way, Dan, the scrolling is not working. And anyways, I'm going to continue answering your questions, guys. So next question comes from Jessica. If I was temporarily laid off due to COVID last year, can my employer hire new staff before bringing me back? So I like this question. It's a question that I get asked very often, Jessica. The answer is the temporary layoff was actually illegal to begin with. Your employer did not have a right to lay you off temporarily. So when we're asking, can they bring someone else? In a way, it doesn't matter because it's already illegal. So whether they bring someone or not, it makes it it's already illegal. So the illegality here is not who they bring back. The illegality is that they shouldn't have put you on a temporary layoff to begin with, even if it's because of COVID-19. So Jessica, the options that you have is you can wait to see if you get called back to work, or you can choose to treat this as a termination of your employment and get severance. Severance could be as much as 24 months pay because there's no automatic right to lay you off temporarily. So once we know that, it's not a question of who they call back. It's they shouldn't have laid you off to begin with. If you want your severance, Jessica, contact me. I want you to reach out to me. You and anyone else can do that through employmentlawyer.ca. Again, employmentlawyer.ca. Thanks for that, Jessica. Next question comes from Angel on Facebook. Since January 14th, our office is closed with no date for reopening. How should this be treated? We have information that the office has no intentions of reopening, but they are not telling us this directly. So the first question, Angel, is depending on the type of office that you're working in, the question is, are they required to be closed based on government regulations? If they're required, if they have to, they cannot open, no matter what they want to do, they're not allowed to open, then nothing can be done right now. What can be done is when they are allowed to open, if they don't open, they'll have to pay you your severance. Okay, absolutely, potentially as much as 24 months pay, but that's only when they're allowed to open. If they are allowed to be open now, but they choose not to open, again, that is something that is a termination of your employment, and you can get severance now, okay? So deal with it when they're allowed to open. If they are allowed to open, now or in the future. If you're not back at work, call me. not a month later, not a week later, right away. And you can call me and contact me through employmentlawyer.ca. Okay, employmentlawyer.ca. Great questions, guys. Love these questions today. So I'm going to continue. Ask away. We have plenty of time. John Michael on Facebook has the next question. What is the purpose of a mediator in negotiations when apparently they can't advise or have control over the two parties? So a mediator is very effective, okay? Because a mediator, the nice thing about a mediator, because they're usually a very experienced person, a neutral person, not listening to them is silly. And let me give you an example. Let's say we go to mediation and the mediator tells the employer, you're going to lose in court if you don't settle today. Well, for that employer to say you're wrong is very risky, because chances are what the judge would do in court is the same thing as what the mediator said. So if they think, wait a second, if a smart, neutral person says we're going to lose, we better settle because we don't want to take the risk in court. So a good mediator could be very effective. 90% of cases, in employment cases that go to mediation, settle at mediation. Extremely effective. Now, some mediators are better than others. I know exactly who to use, so I use the mediators that are top employment law mediators. But it's very, very effective. A mediator cannot make someone do something, but they can exert a lot of pressure. Okay, it's very, very effective. So, John Michael, if you have a follow-up question about your specific situation, please ask away. Happy to answer it. Northern Mustangs has I love that name, on YouTube, has a follow-up question. If settled a severance in title, there was difference in hinges. Sorry, I'm not sure I understand the question. If settled the severance entitled, that what difference in hinges? Sorry, maybe there was some typos or autocorrect there. So Northern Mustangs, ask your question. I'll be happy, I'll be happy to answer it. Okay, Layla, is it mandatory to provide proof of vaccination to employers? That's a great question, and the answer is no. Okay, it's not mandatory. It's not mandatory to be vaccinated, and it's not mandatory to provide proof. Okay, so you can absolutely refuse if you choose to refuse. An employer cannot penalize you for not being vaccinated. That could be potentially a human rights violation. If you are in a situation where your employer is putting pressure, threatening, demanding things as relates to vaccinations, call me. Okay, don't sit on that. Let me deal with that. And by the way, you can reach me. I've said this before, but I'll remind everyone through employmentlawyer.ca. Okay, employmentlawyer.ca is the place to go to contact me. And you see that on the screen right there, employmentlawyer.ca. You'll see, by the way, a lot of other information there about employment law, about workplace rights. So it's a great place to go to. Now, I get asked, so by the way, ask your questions. I get asked often, when should I be contacting you, Lior? When is the type of issue that I need to pick up the phone or send an email to you right away? So let me go through a couple of these, but I'm doing that as I'm waiting for even more questions, so ask your questions. The main time you probably want to contact me is if you lost your job, okay? And the reason for that is if you lose your job, you have very significant termination entitlements. There's significant amounts that are legally owed to you. The problem is that for 90% of people, even more than 90%, what your employer gives you or offers you on termination is a lot less than what you're actually owed. A lot less. I'm not talking, well, it's 10% less. I'm talking 60%, 90% less. So if you lost your job, you have to contact me. Because if you don't, you will find out when it's too late that you were owed another 10 months pay and you didn't do anything about it. You simply signed off on it. So probably the main time you call me, you call any employment lawyer really, is if you are looking at that severance letter, you lost your job today, you call. And we have to assess what you're owed at that point. The good news is, if you're owed more, and in over 90% of cases you are owed more, it's not difficult to determine what you're owed. Okay? If you're owed more, it's not difficult to get you what you're owed. So please, let's get this resolved. It's not a complicated thing, but there could be tens of thousands of dollars at stake for you. So please do the right thing. Employmentlawyer.ca. But for now, answering questions. That's what I want to do. That's why you're here today. So ask your question. Next question on Facebook from Shanila. And if I mispronounce, again, my apologies. If someone is working for a company for 9 years in a dental office, and the broker agent who is helping the dental office the owner to sell the office said many people make the assumption that they are also entitled to severance pay upon the sale of a practice, when in fact this is incorrect. Severance pay only applies to circumstances that are usually not relevant for dental practices. So first of all, you get severance pay, Shanila, if you lose your job as a result of the sale. If you don't lose your job, you continue working with the buyer, they inherit your service and you're not let go, and because of that, no severance is paid. But if you lose your job working for a dental office, whether it's because of a sale or for any reason, yes, absolutely you're entitled to severance. You're entitled potentially to as much as 24 months severance, absolutely, but only if you lost your job. So the sale doesn't automatically mean you get severance, but you absolutely get severance if you lose your job as a result of it, okay? If you lost your job, will lose your job, severance has to be paid. No question, no exceptions, all right? Employmentlawyer.ca if you want to reach out to me. And in it to win it, I reached out to you a couple of weeks ago with a question about being fired without cause on medical leave last year. No progress on litigation. How long should settlement take? Again, I don't know anything about your case, so I can't answer that. But you know, there should certainly be progress. There should never be any waiting or times when nothing happens. If you started a case last year, it should be resolved by now. Okay. If you have another lawyer and you want a second opinion, let me know. Happy to give that to you. That can't be just situations where you sit. An employee should never be sitting and waiting. There should always be something happening, moving the matter along so that it can get resolved, so you can get paid what you're owed. Okay? That's all I can tell you. If you want a second opinion, please don't hesitate. Great questions, guys. Amazing questions today. Ask away. Next question from Amanda on Facebook. If I have an elder contractor that has shown early stages of dementia that is starting to affect the reputation of the agency based on his forgetfulness, temper, etc., and becoming a liability, it's a rotating yearly contract. What are the grounds for legally terminating the contract? So you cannot let someone go because of a disability. What you should be doing is writing to the employee, expressing the concerns. Like, here's the concerns we have. And if there's a medical reason for that, let us know. If there's no medical reason, we're giving you a disciplinary warning that if you don't shape up, we're going to let you go. So you have to put the onus on the employee to tell you that there's a medical reason. If they don't say it, they say, no, there's no medical reason, then at that point you can discipline and potentially terminate. But don't terminate until you know. If you simply believe there's a medical condition and that's why you terminate, that's potentially a human rights violation, okay? Very illegal, so please don't do that. Great question, again, thank you. Next question from Darius. My employer let me go the week following schools being closed. What are the next steps for me to do? So you gotta call me. We have to ensure that you get what you're owed. So you're owed severance based on your age, your position, and the length of your employment. And that could be anywhere from 2 months pay to 24 months pay. So for Darius and for anyone else that may have lost their job or are worried about losing their job, here's how you can find out right this very moment how much you're owed. Go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. You will see our severance calculator tool there. Okay, that severance calculator allows you to find out how much severance you're owed. It's anonymous, it's free. You answer 3 questions and you're done, and you find out how many months pay you are owed. So Darius, go to pocketemploymentlawyer.ca. If you did not get what you're owed, call me, okay? Call me right away. I'll help you get what you're owed. To contact me, of course, employmentlawyer.ca. From Northern Mustangs, if an entitlement of severance is settled, is there a difference with any contingency on a lump sum versus continued payment? Well, a lump sum is a payment you get now, one payment. Continued payment is a payment over time. Depends on what you negotiated. Most settlements, we negotiate a lump sum payment, no strings attached. Sometimes with a salary continuation, there's a string attached saying that if you find another job, we will only give you half of what's outstanding. So it depends what was negotiated. Most settlements, we negotiate lump sum payment, no strings attached. If you want to talk about your resolution, please let me know. employmentlawyer.ca. Next question is from Deco. Deco, maybe I mispronounced. I do apologize. What is the fair severance after wrongful dismissal after 18 years of service in a government agency? So first of all, Deco, the question is, are you part of a union? If you're part of a union, unfortunately, you're not going to really be getting severance. Unionized employees don't really get severance. You may have a right to have your job reinstated, but you're not getting severance. And the only one that can help you, if you're part of a union, is the union. If you're not part of a union, then your severance is based on the length of employment, which we know is 18 months. But also, we need to know your age and the type of job, what kind of a job you had. But severance for you can be anywhere from 16 to 24 months, depending on your age and depending on the type of job that you had. But again, Deco, that's only if you are not part of a union, okay? Not part of a union. Please remember that. And by the way, for everyone, what we talk about on these segments really only applies to non-union employees. It does not apply to unionized employees. Unionized employees have different rights. It's in the collective agreement, and the only one that can ever help you with a workplace issue is the union. No matter what, it has to be the union, okay? So thanks for that. Northern Mustang says that they watch this segment and the TV show often. That's great. Thank you for that. I appreciate you watching. Let me just see. Okay, so Deco says she's not part of a union. So if you're management, again, depending on your age, 16 to 24 months. Have you been let go, Deco? Do you want to tell me what you've been offered so we can assess what you're owed? You can do that right now. I'll tell you. So by all means, if you have questions, follow up, guys. Anyone that's asked a question, if you have a follow-up question, now is the time to ask. So another question came in just as I was about to say something. And this one is from Tara. My employer laid me off on the emergency leave. How long can they keep us on an emergency leave? So they actually can't keep you on an emergency leave. You're allowed to treat this as a termination now. Okay, you right now can say, by putting me on this emergency leave, that's a termination of my employment. You owe me my full severance now, not later. Now, if you choose to accept that layoff, it could potentially last until March 2022. So another 11 months. But that's only if you accept it. The other option is to treat this as a termination right now and get severance. So, Tara, if you want to get severance right now, if you don't want to keep waiting, you can contact me now and I'll help you get that severance. Very important question. Probably one of the main questions I've been getting over the past year is, can my employer put me on an emergency leave, on a layoff because of COVID-19? And the answer is no in most cases, in the sense that you can choose to treat that as a termination of your employment. Okay, very important. Next question from Darius. Is there a difference between being laid off or being terminated? Does it change whether you get severance or not? No, it's the same, different terms for the same thing. If you lost your job, you are owed severance. The only time you will not get severance, Darius, is if you did something so bad, so awful, that the company lets you go for cause. Now, that's only if you did something terrible. If you did, then yes, you will not get severance. Any other situation, laid off, terminated, fired, let go, whatever you want to call it, if you lost your job, you are owed severance. And for Darius and everyone else, as I said, to find out how much you're owed, pocketemploymentlawyer.ca. It's so handy to use, so easy. You can find out now in 10 seconds flat how much severance you're owed, whether you've lost your job, whether you're worried about losing your job, whether you're just curious, or maybe you want to find out for your mother and father, if they lost their job, how much they're owed. Pocketemploymentlawyer.ca. You'll see our severance calculator tool there, so you can use it free, anonymous, easy to use. Check it out. So let's see here. We're going to continue answering questions. We have some time. Ask. Please don't ever hesitate. From Dave on Facebook. What may the repercussions be if I decide not to have the vaccine due to my beliefs? Can they let me go, or is it up to the law if there is one? I have been given negative feedback on my beliefs in not wanting not wanting it. So I'm interested in what may happen, as I'm not the only one who feels that way. Thanks in advance. So your employer cannot let you go because you refuse to be vaccinated, as long as you're able to do your job safely. Otherwise, your employer cannot require the vaccine as long as you are able to do your job safely. Okay, very, very important. That means you can't be fired, punished, threatened, pushed, none of that. If that happens, you call me. Now, a lot of employers are not necessarily going to understand what I said, and they may give you ultimatums. They may threaten, they may push, they may even let you go. If that happens, again, all I can do is deal with it when it happens, but generally speaking, the employer cannot make you. Now, the government at some point may decide to intervene, and the government may create laws that say you have to be vaccinated to work. I don't think they're going to do that. If they do that, then the employer can make you, because the employer has no choice. But unless that happens, and the government has said that they're not going to do that, your employer cannot make you. If they try, give me a call. Okay, Dave? So hopefully that explains it. All right. Next question. Again, by the way, to contact me, I said that to Dave and to others, to reach out to me to have a private discussion after. employmentlawyer.ca. You'll see my bio, my picture, my team's bios, my phone number, my email address. It's all there, employmentlawyer.ca. See on the screen right here, employmentlawyer.ca. Okay. Dakel says, okay, you've been offered 12 months. So again, Dakel, the only thing I don't know is your age. Can you give me your age? But even if you are young, you're still going to be owed more than 12 months. Probably at least 16 months, and could be as high as 24 months. So if you've been offered 12 and you're owed 18 months, for example, that's a wrongful dismissal. Okay, a wrongful dismissal is a situation when you've been let go and have not been offered or paid proper severance. So 12 months, you've been there for 18 years as a manager, you're going to be owed more than 12 months. So what you need to, you're 45. So yeah, you are probably at around 16 months then. Okay, and again, depending on the seniority of the position, it could even be 18 months. So 16 to 18 months is the range for you. You've been offered 12. So there's another 4 to 6 months pay that's owed to you. That's the bad news. The good news is it's not going to be difficult to resolve. I want you to call me or email me. employmentlawyer.ca has all that contact information, and I'll be able to help you get what you're owed. It's not hard. It's not going to be a long process. It's not going to be a difficult process. So reach out to me, employmentlawyer.ca, and I'll help you get it. Okay? Please remember that. Don't accept 12 months if you're owed 16 or 18. Why would you do that? It may be harder to find another job these days, so you do not want to accept less than what you're owed and then regret it. Dave says, thank you. I appreciate that. Guys, this has been a great session. I really enjoy doing these sessions. I hope that you guys get value out of it. I hope that you guys learn something or maybe feel better about your situation. But as I said, you may have follow-up questions. We have 30 minutes here, but I can't get to everything, and you can't get all your questions answered. So go to employmentlawyer.ca. Hey, I'm going to take the last couple of questions. From Shane, I'm 51, terminated due to COVID, have multiple disabilities. Worked as a receptionist. Do the rules apply to me? Yes, absolutely. You are owed severance based on your age, position, and the length of your employment. In fact, you could be owed even more because you have a disability, because it's going to be harder maybe to find another job. Plus, if you are let go maybe because of your disability, that could be a human rights violation. So absolutely, Shane, you have to contact me as soon as possible. I will help you get what you're owed, employmentlawyer.ca. Let's see. So Darius asked a question that a lot of people want to know. What is the cost of using your law firm? Most of our consultations, not all of them, we try to do most of our consultations for free because we understand people have difficult situations. In some cases, a small portion, we may have to charge an initial fee for our consultation, but most of them are free. Most of our cases also that we take on are on a contingency basis, only on a percentage basis. So for most people, it doesn't actually cost anything to retain us. Good question. I will take one last question here. Let's see. I answered already the vaccination question, Gita. from Big Z7. Employer owes me 2 bonuses but has not paid them for months. Well, let me give them a kick in the pants. Okay, a letter from me will usually do that. It's easy to get this, so you will get what you're owed. Contact me, employmentlawyer.ca. Well, you know what? I'll throw one last question from John Michael. Are recorded phone calls between an employee and employer admissible in a mediation or court case? Yes, they are admissible in most cases, as long as at least one of the, as long as the person that recorded it was part of the discussion. Okay, absolutely. Guys, this was another great session. Wow, whirlwind session. I enjoyed it very much. Hopefully you've learned something, but please don't wait till next week when I'm back here. Ask your questions today. Contact me today if you want to through employmentlawyer.ca. Again, employmentlawyer.ca. You see that right here on the screen, employmentlawyer.ca, to reach out to me, phone number, email. It's all there. Check it out for yourself. You'll learn a lot about employment law. But I will be back next Wednesday for another session at the same time, same place. So please join me again. And if you have any people that you know, friends, family, that have been impacted by COVID-19 with their job, have them reach out to me. Don't have them just suffer and wonder. Tell them also to go to employmentlawyer.ca. Thank you, everyone. Take care of yourselves. Stay safe, and we will see you soon. Bye-bye.